Hello, everyone. Welcome in. Let's go over the oral arguments that happened in Alexee's case today. With this, we are starting with the defense. I saw a lot of the sentiment about how everyone felt about the state in the line of questioning, how everything went for the state side today at oral argument. And I will just say this before we get into it. Should we lose on Miranda as far as the state side? That is fit into the trial strategy for how I see a path to a guilty verdict for the state. I am not relying on Alexee's statements that happened inside the hospital room. I'm actually counting on not using any of that information because it is the one potential moment that Alexee could look sympathetic. I find it to be much more sinister should the evidence about Alexee begin and end with her running to the bathroom. That's much more sinister and doesn't leave any room for a sympathetic interpretation. So with that, I'm not very upset with what happened as far as the state side today. You can tell that the justices are very concerned about the Miranda issue. But with Ms. Fairberg, for Alexee's side, for the defense here, they pressed on privilege, which is much more important in this case and has much more at stake for potential child abuse cases in the future. And we're going to get right into the switcheroos trying to happen, in my opinion, from the defense. And so, let's just start this off.
Prepared to proceed.
Thank you, Chief Justice. My name is Amber Fairberg on behalf of the defendant, Alexee. Good morning, Chief Justice, justices of the court, counsel. As I said, my name is Amber Fairberg. I represent Alexee Trevizo, the defendant appellee. The legal issues here, although that conversation got somewhat convoluted, are actually relatively straightforward. It's the ramifications of this case that are extraordinary for Ms. Trevizo and for every vulnerable patient in New Mexico, and for the state's commitment to safe, confidential reproductive health care. And even more importantly, to maintaining the line that separates medical care from police investigations. Physicians and medical personnel take on the role of caregiver. Police take on the role of investigator. If we accept the state's position in this case, that line completely disappears. And it's to the detriment of New Mexico patients at their most vulnerable moment. Police are in the emergency department every single day. This is something real live doctors have to navigate every single day. And the people who are there are inherently at their most vulnerable moment. There are guidelines here. The state's position is essentially there is no limit. If there is a reason to report, and I want to get into later which reporting statute is actually applicable here. I would argue it's a suspicious death and not child abuse. Those are two separate reporting statutes. But the state is arguing if there's a duty to report.
Okay, I'm pausing here because this is the first switcheroo that I was talking about. Notice that the defense would like this to be framed as a suspicious death report, not as a report of child abuse, because child abuse would automatically waive the privilege of Alexee in this case. It just would. 11504 D4, you've heard it here till we're blue in the face. You now heard it a bunch in this hearing today. That's because it is so decided already in New Mexico that child abuse is not privileged. So here we see them already trying to frame this as a suspicious death report, not a child abuse report. Perk your ears up. That's a red flag right here, and it's not going to fly for me. We will continue.
To report, there is no privilege. There is no Miranda rights. There are no more rights. We just go on in this joint investigation.
I'm not sure that I agree that that's where the state's gone. You're blending the two. I think Miranda, the argument as I understand it from the state, isn't related to the duty to report. I think the duty to report becomes important in the privilege conversation that I really do want to explore with you today. But Miranda just seems to be, they were invited into the room and they didn't do anything. They were polite, they were nice. I heard that a lot. And therefore there was no detention, no interrogation.
Yeah, thank you for the question, Justice Bacon. And you're right. You're absolutely right. There is the mandatory reporting falls under the privilege issue, where I think the state is largely mistaken. And then, but let's talk about Miranda for a minute. Let's talk about that custody, because all of the cases that we just heard counsel cite are completely distinguishable here.
So when the state agrees that there was no medical reason for having the police officers in the room, does that bear on Miranda?
Absolutely.
Tell me how.
Absolutely. Well, to answer your question, Justice V. Hill, there are basically two universes we can be in. We can be in an investigatory universe where Miranda applies, or we can be in, we're here to support the doctor, and we're in the medical universe and privilege applies. The state can't thread the needle through those two by admitting that there is no medical purpose for the police to be in the room. That's effectively an admission that they're there to investigate a potential crime.
But is investigation the same as interrogation and detention?
That question doesn't go to custody. I am interested in that. I mean, does the answer, Senior Justice's question, mean they're in custody? Because then you get to interrogation.
Well, I want to make sure I understand your questions. So I want to make sure I understand your questions appropriately before I answer. There is a difference between investigation and custody, but in this case, there wasn't. In this case, there wasn't. And the reason is because of that pre-confrontation conversation that occurred in the hallway that the justices were discussing earlier. And that's that conversation where police are told by the charge nurse that she entered the bathroom to, and again, the charge nurse never treated Alexee.
That really seems related to interrogation. We're talking about custody. The question is, was she restrained? Was she free to leave? Those are the kinds of things we're looking at when we're deciding whether she's in custody. And what I'd really like to hear your take on the two cases where custody is an issue in New Mexico, and we're dealing with medical care emergency rooms, and that's Ibarra and La Couture. Ibarra, we have a defendant who is clearly in custody. He's been arrested already, and he's taken for medical treatment in the emergency room. And then we have La Couture, where they're not in custody yet. Tell me how those cases bear on this situation.
Absolutely. Ibarra says, and I don't have the pin site on me, but Ibarra says, I do have it. Ibarra uses the term an inherently coercive environment to describe the emergency department. And that's directly contrary to what the Court of Appeals said in La Couture, which effectively said this is just a normal situation, but that was factually distinguishable.
But Ibarra was already in custody. There was
Correct.
no question about custody in Ibarra.
Correct. Your Honor is absolutely right. The reason it matters, though, is because that inherent coercion also goes to custody under Munoz. Munoz gives us, the conversation earlier with counsel got really focused on custody only being a restriction of freedom to the degree normally associated with formal arrests. But in New Mexico, it's disjunctive. We have two ways that somebody can be in custody. There's that way, which normally comes with handcuffs and everything else. And then there's the second, which is that a reasonable person in the same situation, and in this moment, let's put ourselves in the mind of a reasonable 19-year-old high schooler, would not feel free to leave. And that's where Ibarra, I think, is so important, Your Honor, because it talks about the inherently coercive environment of the emergency department and cautioned police against exploiting it.
I ask you just
Yeah.
in answering that, can you, because the state did, can you, in discussing custody, talk about the 2 minutes prior to the officer telling her that she was detained versus what happened after? Because the state seems to be breaking it up like that. And you might not agree. I'm just wondering if you can address that. Because in my mind, that could possibly be an issue. The 3 minutes prior to them telling her she was detained.
Correct. Yeah. So the questioning started 3 minutes prior to them confirming that she was detained. To my mind, Your Honor, the reason that doesn't bear on this case in the way that the state wants it to is because that was a confirmation sheet. And he said earlier, we heard counsel say, this isn't a whodunit. This isn't who had the baby in the bathroom. So there's nothing that was stated there that would have taken police from a place. And that's where that pre-confrontation comes in with the nurse, where he says, she went in there to harm her pregnancy. She's lied the whole time she's here. She's gonna lie to you, and she killed the kid. So there
right here, this is about to be like her strongest point, but it also has flaws, right? So she's basically saying that the police are going into Alexee's room, and based on the reporting of charge nurse HT, who didn't even care for Alexee, that they are going in thinking that Alexee is in fact guilty, in fact a suspect, in fact did do this without even having all of the information. At that point, I don't believe the baby had even been viewed by the officers. So with that in mind, she's trying to pull the officers away from actually just investigating. And as you keep hearing them say, is this an investigation stage still? Because that is the gray area. There is a defined moment for custody, and there was no interrogation, not done by the police and not by the doctor either. So essentially, it comes down to, does the reasonable person believe that they are in custody at that moment? And she's trying to argue, well, that doesn't even matter. The police believed Alexee was in custody at that moment, and it just furthered their opinion about Alexee being in custody at that moment. But I would argue against that and say they simply were investigating a potential crime, and Alexee admits that it is her baby and that she put the baby in the trash. That is enough for the police to detain Alexee. Before her admissions, they may not have been able to detain Alexee. And she did hold the right at that moment to remain silent, to not speak to anyone, and to leave and force the officers to detain her at that moment and say, am I under arrest? If not, I'm leaving AMA and I'm not talking to anybody. She had all the rights in the world at the moment of the police and the doctor entering that room. Okay. So with that, she's trying, the defense attorney here is trying to string this into something that, in my opinion, it's really not. Again, Miranda, for me, isn't the main issue. I'm not extremely worried about this, but she's doing her best to try and put up a smoke screen and make it as so that this investigatory phase is already presumed with Alexee as the one and only potential suspect. They were just investigating at that point. I've said that this whole time. That's just how I perceive it. But the defense attorney right here is doing the best they can to try and smoke screen this information. Sorry if that was a little too drawn out. We can get back to this here.
They're operating under, we're in a homicide investigation now. She's our only suspect.
And I think the through line of what you're saying is Miranda doesn't require confirmation by the police that you're being detained. I mean, our case law all over the place handles cases where there is no confirmation.
Absolutely. And the one thing that we haven't yet addressed, Justice Bacon, is the main difference between those cases on which the state relies and this one is the placement of police, where they're either just in the emergency department, they happen to overhear, or they're standing back, and there's this independent conversation. What we have not seen in any of those cases that makes this one markedly different is that these officers were physically blocking the door. We heard counsel talk a lot about that video. In that video, we see Alexee Trevizo on the bed, hemorrhaging in a hospital gown. Those are the circumstantial ideas, right, that we talked about earlier, that your honors talked about earlier, in terms of circumstantial custody, that she's not free to leave. But that's not what puts her in custody for Miranda purposes. I mean, that's part of the coercive environment that they're exploiting, that they're taking advantage of here. But the reason she's in custody is because she has 4 authority figures acting in concert, only one of whom she's ever seen before. That's the doctor, the charge nurse. And as if you've all seen the video, he's a large man who aligned himself very strongly with police. These 3 men walk into the room and they're physically blocking the door. The operative question for the court is, would a reasonable 19-year-old high school girl In that situation, feel free to leave. And the answer is no. Even if she wasn't hemorrhaging, even if she wasn't hooked up to an IV, even if she hadn't just experienced the first vaginal exam of her entire life and the precipitous labor and delivery of what the defense posits was a stillborn in the bathroom. Those all contextualize it. Yes, Your Honor.
No, I don't mean to interrupt you, but I really do want to talk about the privilege. We have not had an opportunity with the state to really talk about the privilege either, but I need you to identify something pretty specific to me because I don't know the answer to the question.
Absolutely.
What, to your client's mind, did the doctor say? What's the actual violation of the privilege? What are the words spoken by the doctor that you assert are a violation of privilege?
I'm not sure that that's the way, Your Honor, that I conceptualize the privilege. The privilege is a rule created by this court as a rule of evidence. So the question is, so the doctor can invoke Alexee's privilege for her and should have, but did not. And should have a pursuant to medical ethics and her professional guidelines and did not. But in terms of waiving the privilege, only Alexee can do that. And so this is a
Before we waive, get to, it's a privilege.
Yeah, I mean, why is this? What is
Yeah.
What is the privilege being asserted here? I mean, I know that it's a physician patient, but what is happening? What have you identified as triggering the violation of the privilege?
well, the violation, there's actually two different
Okay,
violations.
then that's what I want to try and
Yeah,
understand.
and you can see this from the court order because we've got the district court made an order, one on the statements made directly responsive to the collective confrontation in the room, and also.
But that's what I want to try and get to, because if the privilege you're asserting that's been broken is the statement of we found a baby in the trash, that's not a privileged statement because it's not about Ms. Trevizo's healthcare. It's just a statement.
I'm not sure I would agree with Your Honor.
Well, let me
Okay.
finish. So to me, that is not a violation of privilege. The remainder, we need to transport, bleeding out all of that information. I might agree with you as a violation of the privilege, but in this context, given the suppression here, I don't think anybody cares because that comes after the inculpatory statements by Ms. Trevizo. And so
I'm pausing it here because this is just an interesting distinction that the justice is trying to make. And it was kind of funny that she's like, yeah, but when it comes to that, nobody cares. And as you can tell, this justice is specifically trying to parse through these statements with a lot of detail, very detail oriented, going through each one of these statements to see if it's a privileged statement, if it's a statement that's subject to Miranda. And from day one on this channel, once the suppression, the defense had their motion to suppress and so on and so forth, I said that the district judge would have to parse through these statements. We said that the district judge would parse through these statements once the judge wanted findings of fact. Took 9 whole months, and the judge didn't give us any particularity as to any of the statements and the nuance that goes to these statements. And so I am extremely relieved to see that the nuance between the very specific individual statements made to Alexee are being taken into account as to whether they are subject to Miranda or privilege. And that justice at least flat out is saying that they don't believe that saying we found a baby in the trash is privileged. So, that should be just showing us a few things as far as what they really think. They are really taking into consideration, just my assumption from that, and really wanting to have an actual medical or diagnosing purpose to the statements or conversation between the doctor and the patient. Because then she gets into saying, well, what about, maybe if it's about the bleeding out and this and that could be privilege, which we've said something probably almost to that exact statement here on this channel, where it's like, if it's about medical stuff, we don't need to have that information necessarily. What we need to have is certain statements that shouldn't be privileged, like the doctor's confrontation and maybe even Rosa's responses, if for some reason we didn't have Alexee's. And so this is a very good conversation that they're having here. We'll continue. I just wanted to pause to say that.
So if that's a violation of the privilege, sure, but it's not what is really at issue here.
What's really at issue here, Your Honor, are Alexee Trevizo's statements. It's not the doctor making a statement. The doctor and the nurse both did violate their duty of confidentiality several times by telling officers, I think you said earlier, Justice Bacon, I'm not sure they should have, but to get to the actual statement that is, there's two realms, but the one that is responsive is Alexee's statement. Alexee's statement, which was made for the purposes of treatment and diagnosis. That's the standard under Rule 504. And the reason here that it is, the doctor comes in and says, I'm sorry, there's police here. We found a dead baby in the bathroom. So this is the first time the doctor has spoken to Alexee, and she made it clear later in an interview, and her actions made it clear at the time, and this is the substantial evidence that the district court relied on, that she wasn't going to get treatment without police present. So this information, the doctor didn't know where the placenta was. Indeed, the placenta was never found. The doctor didn't know anything about the circumstances.
Huge moment right there, you guys. Huge moment right there. We have all assumed, we have never had exact confirmation because Alexee was transferred to another hospital, that Alexee's placenta has been MIA since the night of this incident. No one has known exactly what happened to the placenta. We have all assumed, based on the numerous flushes and the ongoing theory that the placenta had never been found, that it had never ever been found. But now confirmed by one of Alexee's attorneys on the record, the placenta was never found. The destruction of the placenta, I think, is extremely incriminating evidence with or without any of these statements. So we can have the suppressions, we can have whatever may come from this, which I'm not, fully out of, we're not out of the fight yet. I'll have my full, analysis at the end here. But no matter what is or isn't suppressed, it's facts like this that are still going to win this case when it goes to trial. Just my opinion. But the missing placenta screams a cover-up, an intent behind what is happening in that bathroom, and the lack of asking for medical assistance is enough. And I just think that that circumstantial case can still easily be won with or without any of this. And this is a huge moment. On record, confirmed by the defense's own attorney, the placenta was never found. It's really safe to assume that the placenta was indeed flushed, which is just a mind-blowing fact in this case. So that has nothing to do with the oral arguments, but has everything to do with the eventual trial. And that is now a solid fact. The placenta was never found.
Circumstances of the birth. So Alexee's statement confirming that birth is absolutely necessary for her ongoing diagnosis and treatment. The problem here is not, I think where we're a little bit stuck is we're imagining that the police could have come in and maybe the doctor could have said something different that wouldn't have triggered the physician-patient privilege. And I would say, no, the police should absolutely not have been in the patient care room, nor should Dr. Vasquez have instructed her entire ED staff not to interact with Ms. Trevizo except for in the presence of law enforcement. She effectively conditioned her ongoing treatment on their presence.
So why talk to me then about waiver?
Okay, let's talk about waiver.
Yeah.
So here the state is effectively saying, and this is how I understand it, that Alexee has waived her privilege by the presence of third parties. Well, all we need to do is look at the text of the rule. The rule, and instead of me paraphrasing it, I'll just read it because I think that would be probably better. The rule defines confidential communications, and then we can get to the exception, which is the mandatory reporting exception. But the rule defines confidential communication as a communication made privately, not intended for further disclosure. And then this is the operative language. except to other persons in furtherance of the purpose of the communication. Now that has a little bit of a loop-de-loop feel because what
A loop-de-loop feel. Do you hear this stuff, you guys? This is crazy. Let me explain to you this little loop-de-loop that they are talking about. Essentially, they are saying, hey, third parties shouldn't have medical privilege attached because just like this attorney's about to get to here in a second, people have people accompany them to the hospital all the time. It does happen. It happens a lot. But does that third party in the room, in your hospital room, automatically have any privilege attached to their presence having been there, or could it potentially waive that privilege? And here's why this is significant, because that same night, Rosa Rodriguez, the third party witness, the third party to the privilege here, started giving out medical information to the police right away, explaining why they were there, explaining Alexee's history of back pain and constipation and hip problems and all kinds of boohoo. And with that, that's why we don't automatically attach privilege to a third party. People could be sitting there live tweeting from inside your hospital room and telling everybody what's happening to you. And there's really nothing you could do about that. They don't have HIPAA attached to them. There is no actual privilege attached to them. You allow them into the room. You could say, you're not allowed in my hospital room. You have to stay out in the waiting room. Could have happened for Alexee to Rosa, and they would have had to not allow Rosa in Alexee's room. It's not a waiver to privilege, and Rosa had no actual medical necessity. What they're going to try and do here is use this little loop-de-loop to say that Rosa does have some sort of medical necessity for Alexee. But in reality, that waiver to the third party application of privilege should be reserved for things like interpreters, caregivers, people who have to actually be there for the patient. Rosa had no actual, intelligible, articulable medical necessity for Alexee. Nothing. I believe one thing she references here is though they asked her to help her get changed into her gown. Okay. Thanks for letting us know that. We're going to ask Rosa on the stand about Alexee's stomach. Oh my gosh, these people get me really mad. Sorry, I'm a little pumped up on this. But this whole loop-de-loop concept is just trying to dance around the fact that Rosa blows this wide open, like we've said here many times. Rosa waives a privilege. Rosa could blow up the suppression under Miranda if she wanted to, because Rosa could testify to anything Alexee said at any other time. So it doesn't really compute for me. It's frustrating to hear in an oral argument a thing like loop-de-loop be said. Because I make videos and I talk a little silly and stuff like that sometimes too. But I'll be darned if I did not say loop-de-loop in front of a Supreme Court. I digress.
What does it mean in furtherance of the purpose of the communication? We know that from the first part of the rule, which says that the communications that are privileged are those in furtherance of diagnosis and treatment. We also have direct case law on point that says, we look at State versus Roper. And granted, Roper was construing an earlier version of this rule that specifically said family members were exempted from the privilege, from waiver. But the current version of the rule actually broadens it. And it broadens it so that it reflects the reality of New Mexico, which is that no person is going to the emergency department by themselves.
Sorry to pause it again so quickly here, but notice the very stringent language he's using. Nobody goes by themselves. Everybody has someone go with them. I really wish there was more pushback on that, because that's just a very assumptive, you just can't assume that. Many people go to the emergency room by themselves. Many people are not accompanied to any kind of medical visit. There are many people who are alone in this world. So she's over here thinking that everybody's just got this buddy system. Everyone has someone go with them. We should attach the privilege to them because they got to be there. No, no one had to be there. Alexee was a grown adult, 19 years old. And so this whole argument of everyone has someone with them is not valid. It's just not valid. And I hope that when they're taking this under advisement, that they don't consider this, because it's just outright silly, and we can move on.
Every person has a support person, whether it's extended family, whether it's their mother. I mean, and this idea that she's 19 and therefore it doesn't matter, that's not reflected in the law. The law says that any person, it's not someone who's absolutely necessary for care. It's someone who's there in furtherance of that care.
But so the officers are in the room and
Officer,
they are not in furtherance of her care.
I would argue, Your Honor.
Would that be a waiver? I mean, I think the state asserts that that's a waiver, like that she's cognizant of what's happening and makes a knowing decision. I don't care that they're here. I'm going to answer this question. It's not a question, this statement for purposes of furtherance of my care.
Right. I think in that idea, it kind of loops back on there's two things here. One, it loops back on the idea of Miranda, that a statement, any waiver needs to be voluntary. And so for the same reasons, we would argue she didn't voluntarily waive any rights under Miranda. She didn't voluntarily waive any rights.
So, Ms. Faber, assuming for purposes of discussion, assuming that the statement by the doctor, we found a dead baby in the bathroom, was a violation of the physician-patient privilege in the context of everything that's going on, she never had a chance to waive.
Correct. Right.
There's no waiver.
Right. You can't waive a right that you've not been informed.
And she had no, and by the way, a fact I think that you left out, and I don't think you meant to, on the custody, is that the officers were armed.
Absolutely.
Visibly armed.
Absolutely. Visibly armed. And if I could just add one more thing to speak to that, Justice Vigil, and also finish.
All right, I have a serious problem with this justice here. He is just, I've seen him in other ones too, because I've been preparing, and sometimes he literally doesn't even know what's going on. Like, he's like, I don't know about this practice. Can you explain it to me? Like, wasting this other person's time on the floor at the Supreme Court, not having his stuff together as a justice. Sorry, just my opinion, but I'm putting my opinions out there. This is my analysis. He's over here bringing up the fact that police have guns. This is America. Every police officer carries a gun. It's understood, and it should not be even considered in this custody argument at all. It is presumed. It is known. Every police officer carries a gun. I just don't think it's relevant to this issue. And I'm really disappointed in the performance of this justice overall. A lot of these justices had valid questions, had very deep thought-provoking questions. And this justice is coming over here like, oh, the police officers, they had guns. And it's like, yeah, and there was a baby in a trash bag. Get your stuff together and let's move it along here and not waste valuable time on insignificant facts. If you would like to disarm the police, take it up somewhere else, Justice. This is not the time and place for it. So I'll get off my soapbox about that, but it's completely irrelevant to the matter at hand. And I potentially expect this justice, should everyone else find a reason to, overturn the district judge's suppression, I expect a dissenting opinion on one or two facts at the very least from this guy. And so we'll just get that on the table right now. But I do believe he's bringing up some kind of belief or issue he may have with firearms in a case that firearms are completely irrelevant, not the time, place, or venue. And I find it inappropriate. Again, just my opinion. I'll get off my soapbox. We can continue.
Finish answering your question, Justice Bacon. They also fit into other persons because the reason is because of what the doctor said. That and the charge nurse verified it and said the exact same thing. No one's talking to Alexee, aka no one's treating her except in the presence of police. So in that situation, they're absolutely in furtherance of care because she's not.
But how is the mom in furtherance of the care? She's actually she was questioning her daughter more than the police were. And it wasn't about her treatment. It was about you did this and you're going to be in trouble and all of those comments. And in fact, if I remember correctly, I think the police even at one point said, please stop. So how was the mom there in furtherance of her care?
I think we have to step back and look at the totality of the circumstances for that. The statements that you're pointing to, Justice Zamora, or from mom are her own reactive statements to what she's just learned. But in the course of Alexee's care, she brought her there as her emergency contact. She was asked by medical professionals at one point to help her get into her gown. She's been going back and forth to the bathroom to knock and see if she's okay. She's sitting by her daughter's side. She's advocating her. That's absolutely in furtherance of care. Just because we now in retrospect think, oh, some of her statements might have been against Alexee's interests, that does not mean that in the moment she was not there in furtherance of care and that the physician-patient privilege does not attach.
So we have exceptions to that.
Correct.
Let's talk about those.
Let's talk about D4.
Let's talk about the statute that also exempts it, the statute by the legislature. We have, interestingly enough, this privilege existence statute seems a fair rule was generated out of common law, 32A45. And then let's talk about those two things, because it seems to be a high burden on this doctor who has an obligation to report a crime. I think perhaps lawyers have that obligation. You know, take a separate factual scenario in which they ask a 25-year-old, you know, stabbed in the leg, I killed somebody. They having that conversation as a doctor and a patient, I'm not sure it means the exception doesn't apply. Why doesn't the exception apply?
So you're saying, why doesn't the mandatory reporting exception apply to the statements that are happening after the collective enters the room?
Or under the statute shall not be excluded on the grounds that the matters be subject of a physician, patient privilege, or of their similar privilege under 32A or 5.
Right. So I think there's a couple of things here. And one of them is that the report was already made to the extent that it was applicable. And I just want to step back for a moment because we've got two operating statutes. The state has focused exclusively on 32A43, but there is also, for your honors, 2411.5, and that's reporting a suspicious death. 32A43, excuse me, is part of the Children's Code, and we know from Strouch and its legislative history that the purpose of that statute is to intervene and protect a child from ongoing abuse. And so hence the mandatory reporters that are reporting abuse. And that statute uses the language that a mandatory reporter, and obviously the doctor is one, if they have reasonable suspicion that a child is an abused or neglected child. And then it goes on to a whole slew of legislative rules that have to happen, including you have to report it either to police or to CYFD. If it goes to police, police need to report it to CYFD. CYFD then gets involved. That's not what's happening here. There's nothing in discovery. There's nothing in.
Okay, pausing it here again because there is evidence that this was turned over to CYFD. It is part of the public record of the released body cam footage. It is Rosa inside the police station, and they talk about CYFD having to come and do their investigation of the home, of Alexee's home, because having found a baby wrapped up in plastic in a trash bag is enough for a protection agency of children to have to come in and investigate and make sure that there ain't nothing else weird or abusive going on in that home, especially in regards to children. It's on the record. It may not be on the record proper here that has been given to the Supreme Court, but CYFD did, by all accounts, have an appointment to come to the Trevizo home, as stated and agreed to by Rosa on the police body cam footage from inside the police station merely days after this incident on the 31st. I know for a fact. And so with that, the proper channels were eventually involved. This all happened within a matter of minutes. The police show up within a matter of minutes. It is not like any kind of healthcare was denied for a certain period of time or anything of that nature. Proper protocol, in my opinion, was had throughout this entire thing. The reason it happened so quickly is because the police happened to be nearby. So should the doctor had to have gone and talked to Alexee before police could have arrived, that likely would have happened. She wouldn't have just left her there bleeding out. But with that, it is true that CYFD was to be involved on the record. We can continue.
In the record that police ever got CYFD involved, because this isn't the operable statute. The operable statute is instead 2411.5, which is reporting a suspicious death. There is no dispute here that doctors did not try to resuscitate this neonate, that they found the neonate cold, blue, very clearly deceased.
I don't disagree with that recitation, but there also is an OMI report, at least according to the briefing. Is this a question of fact?
I think that part probably is a question of fact, but what's not a question of fact, yes, the stillbirth versus live birth is absolutely a question of fact. But the issue of what people knew at the time, as far as a report, there was no OMI report at that time.
So it does triggering the suspicious death statute.
Correct. All they saw was a suspicious death. And so that requires one of two things, either a report to local law enforcement or OMI.
Did you guys hear that? We have to run that back. She stopped herself, I think, from saying all they saw was a dead baby. She stopped and she said all they saw was a suspicious death. Just listen close here. I believe I didn't go back too far.
Statute.
Correct. All they saw was a suspicious death. And so that requires one of two.
Right there. All they saw was a suspicious death. That is a very telling moment, in my opinion. All they saw was a suspicious death. Okay. That is enough to kind of grind your gears there, but I just wanted to point that out because I thought that was interesting. That's all I'll say about it. Let's move on from that point.
Two things, either a report to local law enforcement or OMI. And then it's up to those people to take on the investigation. But even if we are operating in the realm of 32, of the Children's Code 32A43 and 32A45, I would still argue, Your Honor, that any reporting is not prospective reporting. It's not an ongoing duty of some sort of ongoing duty of disclosure. That would de facto turn a doctor and any other mandatory reporter into an investigator by police.
The only thing the doctor was required to report was we found a dead baby.
I would say that the doctor was required to report the basis of her reasonable suspicion for child abuse. So we found that's what the statute says. And that's what happened. We don't.
Now, as you hear right there, the attorney for the defense literally says that the doctor has to give the foundation for a reasonable suspicion of child abuse. So which is it? Is it a suspicious death? Or is this a potential child abuse resulting in death or child neglect resulting in death? And why is there a distinction under the law between child and adult when it comes to an adult harming them potentially? Are children's deaths now not going to be considered in the realm of child abuse? Is it just simply a suspicious death without any implication of child abuse, even though they're a child? And even if it's at the hand of their parent? It's a good question by the justice, because the defense was just trying to tiptoe around that and turn this into a suspicious death report rather than a child abuse report, which would impact a lot of the downstream things from the initial action. If it's not child abuse, then the privilege would be impacted as well. So we'll let this continue to play out.
We don't know that the doctor did it. We think it was and obviously the nurse was the first one to have a conversation with the police. The report was made. Now it's up to them to take on their investigatory tools. It doesn't mean they have an ongoing open entry into her medical records. The other thing that I would point out for Your Honor, especially Chief Justice, I want to make sure I'm answering your question, is that the records referred to in the Children's Code, I would argue generally are referring to the records of the abused child. It doesn't mean, well, now let's look at the suspect and prospectively and in an ongoing manner have access to their records. That's why we have other investigative tools. They could have gotten a search warrant for her DNA. They could have gotten they could have taken her clothes and conducted communications on those. They could have gotten other warrants for medical records. They could have subpoenaed things. They didn't do any of that. Instead, that very night between them and the
Well,
hospital.
some of it is based, some of the duty to report child abuse is based on the mother's records, because the pregnant woman who her toxicology screen might report a basis for child abuse, her self-report or clinical observation. When it's, I think when it's a drug exposed baby. So there's some basis in the statute. We're not just looking at the child.
Correct, Justice Zamora. But what that portion of the statute also shows us is New Mexico's commitment to reproductive health care. And that what that section says is that mom's status as having used drugs is not an automatic showing of child abuse. So I think here, if we're reading it in total, but I still would urge Your Honors, I think that the morass of 32A43 is avoided entirely by realizing what doctors saw, what they perceived, what mandatory reporter perceived was a suspicious death. We're not in the realm of CYFD. That's just not where we are here.
We're in the realm of doctor-patient privilege.
Correct.
If the defendant would have said instead, same scene, and the defendant would have said, the doctor says we found a deceased individual in trash can. And the defendant said, I killed that individual. Would that have been privileged?
Well, Your Honor, I would say under that hypothetical, no, the
Okay.
reason being that that statement would not be for the purposes of diagnosis and treatment.
Okay,
Yeah.
it's fair enough. So let's get to the statements that are suppressed and tell us how that falls. Basically, in essence, the defendant said, baby fell out of me. That, your view, is tied to direct medical treatment because of the hemorrhaging. Understand that?
Not only the hemorrhaging, but what she's describing, what Alexee is describing, what we hear from hospital personnel and what we hear from the state is that from the moment Ms. Trevizo got to the hospital, that she was lying. Well, what do they base that on? That she said that she was bleeding, that she was in 10 out of 10 pain, and she wasn't pregnant. It is surprisingly common how many people don't know they're pregnant until well into that case. So that's what they're basing her lying on. But what it really shows, and
But they delivered at 10.
Not only that, Justice, but also it shows an obstetric emergency. She was probably having a placental abruption. And so what her describing to the doctor what happened in the bathroom would have been extraordinarily important. It is extremely unusual for a woman to be able to go into a space and within an 18-minute period deliver a baby, deliver a placenta, and then walk unassisted back to her room. That demonstrates the amount of morphine that she probably had in her system at that point, because I think, just as a matter of common sense, that's not something you should really be able to do. She would have been, so the idea here is she was in the midst.
Now we have to pause here because honestly, my jaw was hitting the floor as she was saying this. And I know she tied it back to the drugs, the morphine, and the ability to give birth in that situation, and with the facts that we have, no screaming, just none of the typical pain without the standard pain suppressants that people have in American hospitals. It's very standard for epidurals. It's standard for other types of pain suppressants. It is outlandish. And so for her to say how it would have been extremely useful, I believe is the exact language she used, for Alexee to have relayed that to the medical providers and to admit that is very dangerous, because essentially it undermines the entire meaning for the privilege if it's read in a certain way. And this has been our off the wall legal theory here for quite some time, which is if it can be even, potentially hinted at that Alexee's statements were not to further her diagnosis or to further diagnose or treat, then how could privilege apply at all? And one could say that this attorney almost just admits to the patient withholding pertinent information, which could undermine the privilege severely. And so I find that very, very interesting. And another thing that I have a problem with on this is that this is, I believe she said unusual. Now, we're jumping to some preconceived ideas here, which is that the unusual behavior has to be because of some kind of extenuating circumstance other than motive to hide and or murder the baby as alleged. And there are just presumptions happened here, like presuming like these preconceived notions of HT, some preconceptions about other things that are just getting jumped to and kind of glossed over by the defense. Like they admit about HT prior that he didn't even treat her, yet he was kind of spearheading this and that he's the one who made the statements that should invoke Miranda and accused Alexee of the crime to the police, while also saying he never even treated her. So how much weight should the police be giving HT statements even in that moment, one could argue, right? So there's just some like preconceived notions about things that may not work in the defense's favor in the end, like this saying that this is an unusual circumstance. This was very weird to have done. Yeah, it was. It shocks the senses. This attorney also confirmed for us that we never heard of the placenta after this. Was never found. And this attorney would obviously have access to the information from the secondary hospital, which Alexee was sent to in case the placenta was stuck in her, right? So if this attorney is saying that, we've never had a confirmation of that on the record yet. So this attorney is just kind of, at least in my opinion, having some things that upon reflection could solidify more for the justices who may have been on the fence, that there are a lot of issues here to move forward allowing privilege. You can't have it both ways, right? And I'm still a little bit shaky on Miranda, but I don't think that these are the best arguments to show why privilege should be upheld. It's undercutting that and showing that Alexee was potentially deceitful. You have to question why this information wouldn't be shared with hospital staff, yet the hospital staff have to be held to some sort of standard to continue to keep the secret of the baby in the trash. It just doesn't really add up when this goes back and gets thought through, in my opinion. So I will wrap that up and we'll continue.
Placental abruption. The doctor did not know where the placenta was. Had any of that been retained in her uterus, she would have bled out and died. So the idea here that her job, she had nothing for medical purposes to say to the doctor is simply not the medical reality. They needed to have an open conversation to make sure she got the care that she needed.
Can I ask a really different question that's just been weighing on me? So assume the court agrees with you on either Miranda or privilege. Case goes to trial. You've indicated today that the basis of the defense will be stillbirth. Aren't her statements supportive of her own defense that you're working so hard to exclude here?
And that, my friends, is when my jaw hit the floor. Because if you saw my oral arguments video, I said the most important thing to point out in this oral argument for the state is to say that Alexee's statements are exactly what her defense is. And I even went as far to say is that I would bet my bottom dollar that these are the statements that are attempting to be reintroduced through the polygraph examination of Alexee Trevizo. And what would the defense be attempting to do in that situation? They would be attempting to subtract Rosa's statement, which is, I just asked you to tell me the truth. That's the statement that they're most worried about, in my opinion, as the defense. They're not worried about Alexee sitting there looking sympathetic and saying the exact defense that she has. And that's why I've said to you guys, my trial strategy excludes that anyways. I wouldn't want or need that at all. What I want and need is Alexee running down the hall and back, not having told anybody about the baby, and Rosa's testimony. That's really all we need. Obviously, the autopsy as well, which won't be able to be refuted, especially not by Chris Berry, the expert that was enlisted by Team Trevizo. That's all we need. So literally my jaw hit the floor when this justice fired this out and said, isn't this exactly your defense? Like, why are you trying to suppress your defense? And I wonder if they're going to try and get to the bottom of that. I wonder if they're going to really study the record and figure out what on earth is going on here. And maybe, just maybe, that could turn out good for the state. Because as I said before, that's the most important thing in this entire set of suppression issues. Why suppress her defense? Let's keep going.
And so I see, like, you know, you all will be gone. There will be a new attorney involved, probably a public defender, and we will have excluded statements that are consistent with what her defense is. And that just troubles me in a weird way. That's why I said it's just a related but far field question.
Yeah, I think that I appreciate the question, Your Honor, and I'm not going anywhere. I'll be there for trial to the extent that it happens. But that's just not the operative question for the court to think about trial strategy and so on. I would point the court to State versus Gutierrez.
You guys see that? You see that? No freaking answer. No answer for my number one question. Of course you don't have an answer for my number one question because it is the fundamental question. And I know the answer, at least in my opinion. It's in my video about the oral arguments, the X factor that they are trying to subtract. It is ridiculous. This is crazy. And she didn't even have an answer for it, you guys. She just passed it off and said, hold on. No. You don't get to just think about our trial strategy here. No, but we're talking about evidence, and you're the one as the defense over here saying that this will impact everyone and all these patients and everybody and everything. Wait a second. Are you admitting that this is trial strategy now? Okay. No answer. Please take note of that, you guys, because that was a very important question. She said, I know it's like related. It's far out. No, it's the most important question. That's why you thought of it. That's why you got there. That's why you're a justice, right? It's why you're there. I've been looking at this for 2 years, right? They've taken this under, she's right in the moment and got there. You're a justice, like smart, got it, boom. Huge question, very important. No answer. We can keep going.
In which this court has decided that they take a different approach than the feds do, for example, on constitutional rights.
Most things.
On most things. And that approach is, we vindicate her rights because they need to be vindicated, not for deterrence, not for anything else. Her rights were violated. What we need to do here today is try to right that wrong. And then when we get to trial,
she decides to voluntarily use the information.
Correct.
No harm, no foul.
Correct.
Okay.
Exactly, Your Honor.
Thank you.
I realize that I am running with only 38 seconds left to go. And so I just want to highlight for the court, and I want to make sure I answer all of your questions, but I want to highlight for the court the policy impact for New Mexico of this decision, that it really matters. The stakes here just reach far beyond Alexee. If the state's position is adopted, the message is clear. And that's, in moments of crisis, patients can't trust what they say to medical staff will remain confidential. And that's going to chill patients, especially adolescents, especially our rural.
No, I refute this argument, and I just strongly, I strongly disagree. in the moment of ultimate need, of ultimate necessity, that information was never shared. What confidentiality? Alexee never told them about the baby. They had to find baby Alex in the bottom of the trash can, hidden under other bags with trash all around it. She didn't confide in them. There's nothing to keep confidential. I just completely disagree with this framing. This is not how this played out. If the hospital staff saw that Alexee had a stillborn and had no reason to ever even think, or why would they ever even blame that on her when she opens the bathroom door and says, hey, this baby just came out of me, I need help. Then they got the police involved. I'd be pissed too. I'd be like, why are they calling the police on her? That's crazy. She just asked for help and had a stillborn. That doesn't seem like something a guilty person would do. If they were trying to cause that stillborn in some way against the law. Now, that's not what happened. This was kept confidential. We are asking for the doctor to further keep confidential things that were kept confidential from them regarding a potential quote unquote suspicious death, as the defense wants to put it, or a potentially abused child, as the state wants to frame it. And so I just completely disagree with this argument. The information that was relayed was not information Alexee gave to the hospital. It was information she kept from the hospital. So there is no issue about confidentiality, in my opinion, but we can continue.
Patients, especially our vulnerable patients. It will also destabilize the physician-patient relationship that forms the bedrock of our healthcare system. And the district court drew that line correctly. Miranda and Rule 504, the relevant medical ethics, mandatory reporting statutes being narrow, that's where the line lies. In this case, it was completely obliterated. So to erase those safeguards would not only reweigh the facts, we haven't talked about standard of review here, but would not only reweigh the facts, which is what the state's in court in encouraging this court to do, but it would also reshape emergency care so that vulnerable patients would be at risk. And I just want to end on one thought, Your Honors, and that's that this case isn't about whether hospitals can notify police of a suspected crime. They can, and in most cases, they must. It's about what happens after. It's about what happens after that notification. Doctors are caregivers. Police are the investigators. Our law keeps those roles distinct. And it's essential for New Mexico that we continue to keep those roles distinct. And I just want to thank Your Honors for your questions and also ask that you please affirm the district court's order on both grounds, privilege and Miranda. Thank you.
Okay, one moment. Let's see if we have any other questions. Okay, thank you, counsel.
Thank you.
All right, Mr. Thomas. Thank you. 10 minutes.
All right, let's try and bring together some of these thoughts that we threw out during this argument. Number one, the placenta. Anytime you get a fact confirmed by the defense in this case, information is king, right? Anytime you get a fact confirmed by the defense, it is important. Now, the placenta never being found, in my opinion, I would strongly suggest that we can safely assume at this point that Alexee did indeed dispose of it via those multiple flushes that happened. Now, this does bring in the savagery of the act, and I do think this is something that will be hard for the defense to get around. So the fact that we do have this now as a fact is extremely important to me. We must remember that there is testimony as to the end of the placenta being torn and or frayed. And there is also a potential for it to have been a little bit longer than average, nothing like an anomaly or anything, just a little bit longer than average. But the fact that this placenta did break would either mean that some medical reason caused that, or it was broken by Alexee, which seems a bit odd and suspect when you think about it, because the placenta being separate from baby Alex is odd. Why wouldn't you just throw the placenta in with the baby? The disposal seems important, right? It seems to build on the savagery and, on the theme of building, we are now firmly building a timeline about the bathroom from the defense. Very early on in this case, the defense attorney, Gary Mitchell, was talking about this case on one of his many interviews. And he said that the baby was born essentially immediately after entering the bathroom and sitting on the toilet. So now we have the entry, the baby's birth, according to the defense. And now we have some of that time filled up with the tearing and flushing of the placenta, as assumed, since we got confirmation that the placenta was never found. Now, in my opinion, say all this evidence stays suppressed. All we need is the autopsy showing baby Alex was alive, plus certain acts of concealment to make a strong enough circumstantial case that will lead to a guilty verdict on murder. Now, it just so happens that as of recording this, Donna Adelson was found guilty in a matter of hours on a highly circumstantial case. Nothing direct tying Donna to any of the hitmen or the murder, technically. But the mountain of circumstantial evidence did in that jury's mind in a matter of hours after 8 days of actual trial. That's clean cut. Circumstantial cases get guilty verdicts, and they get them quickly because the jury eats up circumstantial evidence. It's usually juicy. They get to form the path in their mind. And the plot holes that are usually created by the defense only leave room for the jury to typically assume the defense's guilt, in my opinion. So with that, I do really think that a huge moment in confirming that the placenta was quote unquote never found is important because, as we all know on this channel, the medical records were leaked. They were leaked from the first hospital Alexee attended that evening/morning, and the second set of medical records were never leaked or released. And with that, no one could officially confirm on the record anything we have publicly and via leak that the placenta was or was not found. It had always been assumed. So the defense attorney in this case just let out more medical information about Alexee, in my opinion, than we even had. And so it just goes to show the irony of one of my final points, but I'll actually jump to it now. This is the rule of completeness. Okay, so say all of this is suppressed. Well, part of the defense's entire case is that no one told Alexee she was pregnant. How are they supposed to establish the fact that Alexee didn't know she was pregnant, which would leave a big open hole of premeditation in the jury's mind? But how on earth is the defense supposed to enter the fact that no one told Alexee she was pregnant without invoking the rule of completeness for other medical conversations to be had? Because that would specifically be a conversation between Alexee and the healthcare provider. So other conversations about potential pregnancy would have to be, the door would be open. The rule of completeness would be invoked, and it would have to be fulfilled. So with that, they are a mess, in my opinion, with some of this medical issue. That's the reason there is a waiver for the privilege when a child is involved. It's because these facts are necessary to get hashed out. And it's extremely ironic that a lot of the defense in this case either uses medical conversations, medical facts, or the exact statements that Alexee made herself that they are trying to suppress. And so with that, we can move on to the next biggest thing that's on my mind. So the framing of a suspicious death versus the reporting of suspected child abuse, I will say you have to give credit where it's due. This is, a smart move on their part, very strategic on the defense's part, but it also is a very big risk because it could read to some of the judges potentially as attempting to sidestep the actual defense that they could try and pose for why this wouldn't be a child abuse report. Now, the best real argument that the defense gave for that is that essentially how they interpret the need to report a child abuse matter is that if the child is in an ongoing state of abuse, right? They kind of zeroed in on that when in reality, that's not the true wording of the law. It is any child suspected of abuse or neglect. It doesn't mean that it didn't have to result in death in that matter. It just means that this is a suspected abused or neglected child. This one just happened to be dead. And so it is a very dangerous argument. Sometimes some of the most strategic and, tricky ones are. If you win, you win big. If you don't, you fall flat on your face, but you didn't have anything to do anyway, right? You had nothing to work with anyways, because they have no rebuttal for the exception to 11504. We heard it 1,000 times today, and you've heard it 1,000 times on this channel. 11504 D4 is the exact waiver to this privilege because matters of child abuse should not be privileged, and New Mexico has ruled that way many times. That is why we saw the introduction of the suspicious death theory rather than reporting child abuse, because then they don't have to address how the exception doesn't apply to a baby wrapped in plastic in the bottom of a trash can, and how that's not potential child abuse or neglect. So happening to result in death, right? And so with that, one of the legal distinctions between what you'd think, oh, well, it's the age, right? That this is a child, like we could put that on the table. But one of the other distinctions for the difference between a suspicious death and the suspected child abuse would be knowledge of other potential facts surrounding what happened to the child. And that is why medical providers have this waiver of privilege, because if they're restricted on certain things surrounding what happened, how can they explain the breaking of the bone or what made them start to suspect something was a child abuse issue rather than just a natural injury to a child or whatever? They are not going to be able to actually get that information across properly if this is the case. And so the suspicion and the knowledge of other information surrounding finding this child in this way is what gives way to this leaning towards the reporting of child abuse or neglect, not a suspicious death. And one of the examples we heard was some guy in the closet, like a closet with all the cleaning supplies, and you find someone dead in there, and you're like, we gotta call the cops, we just found a dead body. What's the difference in this situation? They highly suspected and knew who the person who put the baby in the trash was. It just so happened to correlate with their medical, providing that they were giving to her. And so I do, in my gut, think it's not strong enough. It's clever, it's tricky. Maybe it'll get someone, but I just don't think that the entire panel of justices will see this as simply needing to report a suspicious death, because what happens to the medical providers if it was found to be child abuse and the state somehow found out that they knew more about this and didn't explain that they knew that it was this woman who potentially abused his child, even though it was their patient, and the law explicitly says they're supposed to say that? Couldn't they get in trouble for not reporting? Right? So these are things that they're going to have to think about when you're saying this is a suspicious death versus child abuse, and why and how the hospital staff got to the assumption of child abuse, not suspicious death. They didn't have suspicions. They had facts. They knew who left the bloody footprints from the bloody bathroom back to their hospital room and continued to bleed, right? So with that, one of the very last things I'd like to touch on, because again, whenever we get facts from the defense that we didn't know, we have to take note. The defense lets us know that Rosa helped Alexee put on the hospital gown. Now, take note, this would have to be after Alexee gave birth. And so I would be very curious, number one, to ask Rosa, well, how did Alexee's stomach look? I'm curious about that because we do have doctor's notes that seems to indicate that Alexee's stomach was soft and undistended. But I have a medical theory which will be posed as we get closer to a potential trial. I have a lot of medical things that I'd like, to put out there. But in short, the baby could have dropped a little bit lower. Now, that wouldn't make a fully flat stomach, but soft and undistended could be because the baby was in the birth canal. And by all accounts, the baby came pretty quickly after the stomach was being assessed by the doctor. And by all accounts, the doctor said they didn't get a very good look at the stomach because they were moving around. That's what the nurse, Chris Sanchez, said. And we just don't have a very clear description of Alexee's stomach. And so anyone who did see it right before or right after the birth, very important. Past that, could one think or wonder, or could this be an indicator that once the baby was disposed, Alexee felt more free? Why not put on the hospital gown before the medical emergency? That makes no sense. Once she had a medical emergency in the bathroom, according to the defense, Alexee didn't inform anyone of the medical emergency, but did change into the medical gown, which to me, in my opinion, indicates that she was getting more comfortable. She was past something that made her more comfortable with putting on the hospital gown. One could say, well, she was bleeding a lot. Well, the defense keeps saying she was bleeding a lot and hemorrhaging when she got there. So the blood didn't change it. So she sat there and bled in her sweats until she went into the bathroom. So what changed after going to the bathroom that made her want to put on the gown? And why would Rosa need help with that? Was Alexee maybe potentially comfortable with changing because now it was over with? And was she potentially wanting Rosa's help or needed Rosa's help to try and show I'm not pregnant? Because now the baby was no longer in her stomach. Maybe the stomach wouldn't have looked as large and protruding. Very suspicious. This is a huge piece of evidence. Huge. Why on earth would Alexee need Rosa's help? By all accounts, she just delivered the baby. She walked right back to the room. She didn't seem to be needing any medical assistance. She had just, from what we also found out, potentially just ripped up a placenta and flushed it 1,000 times. Why need assistance with your medical gown? She didn't seem to have a twinged back. She was walking back just fine. Wipes her bloody hands and throws away the trash, the rag into the trash. Why? This is huge. I'm going to have to mull this over. If you have any thoughts as to why Alexee would need help putting on her gown, why enlist Rosa for that? Why is that on the defense attorney's mind to be bringing up in this oral argument? That's what they brought up. That's very weird. It's very weird. It's weak because it doesn't show a medical necessity, but we can read into it much deeper. So I'm very curious if you guys have any opinions, leave them down below. In the next video, we'll be going over the state's original argument and their rebuttal. And then we wait for a decision. Justice for baby Alex. Thank you so much for making it this far in this video. If you have any comments, questions, or concerns, please leave them down below and I'll get back to you as soon as possible. And I do genuinely enjoy the conversation. If you're interested in following cases like the Alexee Trevizo case at trial, please subscribe as I'll be covering all along the way with the legal focus. It's your Friday. I'll see you in the next video. Goodbye.